Okay, welcome everyone, and thank you for joining us for our 6-member SMSF webinar. My name is Emma, and I'm a solicitor here at Merthyr Law. So today, Kieran will be discussing the recently enacted laws that have increased the maximum number of SMSF members in a fund from 4 people to 6 people, and that started in 1st of July. He'll also be exploring the mechanics, logistics, opportunities and risks associated with this change. So for those of you who don't know, Kieran is our self-managed super fund specialist here, and so he'll be able to answer any of the questions you have on this topic. Before I hand you over to Kieran, there's just a bit of housekeeping we should go through. So if you have any audio issues during the webinar, please feel free to phone in on the numbers that I've sent through on the chat function, which you can access from the bottom of the screen. Also, we would like this to be a very fun and interactive webinar. So if you have any questions throughout, please feel free to ask them. You can do so also through the chat function, or there's a Q&A function at the bottom. We'll either answer your questions throughout the webinar or at the end, whenever it's appropriate and relevant to the things that we're being discussed. And everybody get creative, because the person with the most creative questions also wins a prize, which is one of these. So yes, I'll pass you on to Kieran to get it started.
Thanks, Emma. And so everyone, Emma Pradella, one of her biggest fears is public speaking. So of course I make her do these types of things to face these fears. So you did a fantastic job in your first introduction to a webinar, Emma. And look, these webinars are kind of hard, from our angle. Unlike where I'm presenting to a room full of people, I don't know that you can hear me and I don't know that you're there. So using that chat functionality and getting involved and, paying us out or making comments, those kind of things, just make it seem like, you guys are there and we're in the room. So enjoy it when you do that. And there's red wine and white wine, and usually we have a nice bottle of wine there, and Emma is the one who will decide who gets awarded that prize at the end. So it's absolutely up to her discretion who gets the bottle of wine, and I'll liaise with you about what your preferred drop is, about what we've got on offer there. So please, it's much more interesting if you guys get involved in these topics. If you've got a question, someone else probably does. I probably haven't explained myself too well. So look, today's topic is 6-member self-managed super funds. So this legislation has been in the pipeline for a couple of years and just kept on getting knocked back, but finally, passed near the end of last financial year. And is in action as of 1 July 2021. So this is the rules now. Now, the last stats I looked at, only about 7% of self-managed super funds had more than 2 members. So it's not something that's been widely adopted, but perhaps that's because 4 is not a real good number. Perhaps now that 6 are allowed, that might change. And so I thought, look, for today, I'd use this as an opportunity, not just to go through the legislative requirements and those practicalities, but to try to put our thinking caps on and get creative and think, what can we use these larger self-managed super funds for? So I've put my thinking cap on and I've got a few creative strategies to share with you today, but I'd really love for you guys to share any other strategies you might have, or even bounce them off me to see if they work for how we can use these 6-member self-managed super funds. And look, I guess when limited recourse borrowing arrangements came in 2007, everyone was a bit scared to use those instalment warrant exceptions. And then they were around for a few years before the ATO put out their pronouncement, and they changed the laws too to say these are all the things you could have done with these limited recourse borrowing arrangements, or instalment warrants they were known as back then. But we've changed the rules, so you can't do those things moving forward. So, the early bird gets the worm. So it's a good idea to think about these things, and think what you can do, I guess, before everyone else gets there. And I was listening to Gary Vee a while ago, and he was saying not that this is a change of anywhere near this magnitude, but when TV first came around, people didn't really know what to do with it. So you'd have these broadcasters would sit on a chair, a bit like I'm doing today, and they would just read a story or read the news, and it would just be like radio, except you'd be looking at this boring radio presenter. And it wasn't until a few years where they figured out, oh, geez, we can put images and we can change this up. There's a lot we can do with this media. So today, that's where my cap is thinking, what can we do now that these changes are in place? So what are the changes? So the existing rules have this concept of for it to be a self-managed super fund or any reference is a fund with fewer than 5 members. And I never quite was entirely comfortable with this concept of fewer than 5 members. What does that mean? We can have more than 4, but we've got to have fewer than 5. So does that mean I can have my 2-year-old son as a member because he's not a whole person yet? Look, no one's ever kind of tested that, but it was, a bit of a weird kind of drafting that raises some philosophical kind of concepts. But fewer than 5 is generally taken to mean you could only have a maximum of 4 members of a self-managed super fund or a small APRA fund. And so what's happened with these legislative changes that came in on 1 July? The words have been changed to no more than 6 members. So, it's a bit, I guess it's a bit easier a concept, but, it removes those philosophical conundrums I've got with it, is the maximum number of members you can have in a self-managed super fund is now 6. No limitations that it's got to be a family or anything like that. And that's just the changes. So, if all you were after was a legislative update today, you can tune out now because that's pretty simple, those changes, isn't it? And where are those changes? That's changes to the SIS Act, the SIS regulations, the Income Tax Assessment Act, and the Corps Act. And so, that's the gist of it. The other change, I guess, is for the signing of financial statements. The old law was if you had 2 members or more, 2 members needed to, or 2 trustees needed to sign the financial statements. If it's more than 2, at least half need to sign them. Sorry, and if it's more than, so now the new law is if there's more than 2, at least half of the members need to sign them. So if you've got a 6-member fund, 3 need to sign it. If you've got a 5-member fund, 3 need to sign it. If you've got a 4-member fund, 2 need to sign it.
So Kieran, what was the driver for enacting these changes, do you think?
So good question. The Labor Party was against this. And I guess that's the context of, some would say that they get funded a little bit by industry funds with those big unions who, like as much money in the industry funds as possible. So they get their cushy board seats and that type of thing. And whereas the coalition, the LNP, in favour of, well, 4 is just not enough for your average family, and I think the driver is you've got families that are 3, 4 kids, your good Catholic families can have more. So, they thought, well, if this is going to be a true family environment, it makes sense to be able to allow a couple of more members in there into that one fund. So it is a truer family kind of device. Historically, I guess with only a 7% or less than 7% take up for people with more than 2 members, it might not be that big a deal, but let's have a look. Let's have a look what it is today. Any other questions at this point, Emma?
No other questions at this point.
Okay. So, and the politics, that's why it was delayed for so many years, is, it's just standard kind of politics and toing and froing. The Labor Party still didn't support this change. And I guess in that context too, is there's the potential where, you can pull resources, it might be more attractive for people to roll over their industry fund benefits to a self-managed super fund with their family now. There might be some cost synergies and it might be more attractive for people to do that. One thing to watch out for is, I guess, superannuation in Australia, it's a trust. So it's trust law that applies, and each of the states of Australia has its own Trusts Act. I haven't gone through them all. What I can say is in Queensland, the maximum number of trustees you're allowed for a trust is 4. And I'll get into, a bit of the logistics of that a bit later. Now, the practicalities of how to register these changes with the ATO is just of the last couple of days. I think I got a note on Friday that the Australian Business Register has now been updated to allow for 6-member funds. So that can all be done online electronically now. In that period from 1 July until now, the ATO was encouraging people to wait or otherwise submit those paper forms. But the ABR is updated and that's ready to go. That's kind of good news. We can do all of that online.
So Kieran, what is the percentage of non-family self-managed super funds?
I got no idea. Sorry, I don't have those stats on hand. It would be an interesting question. My experience in practice, and I get involved in the dispute, so I probably see more than your average punter, because the ones that are non-family self-managed super funds are more likely to get into that bust up, whereas lawyers do well out of them, but the members don't, which I'll talk about more. But it'd be a very small percentage, I'd say. I'd say it'll be well less than 1%, but that's just a guess. They say that 93% of statistics are made up on the spot. So what's ahead in my talk today is I'll be having a look at what do we need to look at? What do we need to do to have a 6-member fund or a 5-member fund? Looking at that deed, if changes to the deed are necessary. Looking at what opportunities, having these additional potential 2 members to a self-managed super fund could bring. What are the risks and traps that we should look out for? And instead of doing all of this just by way of dot points, I've tried to do a fair bit of it in case studies because, it's much more, I guess, easier to follow, and it's much easier for me up here talking about a funny family like we see all the time rather than, just dot points. So I'll be doing that in those case studies. And hopefully at the end, we'll have some questions and, some scenarios we can all bounce off and have a little bit of a general chit chat at the end. All right, so deed updates, the technical kind of stuff is, okay, so if in the past we've only been allowed 4 members of a self-managed super fund, and the rules, section 17A, only allow 4 members and 4 trustees, what do we need to do to the deed? Does the deed need to be updated if we want to admit a 5th member on board? And well, it depends. You've always got to read that deed. There are some prescriptive deeds out there that try to replicate the actual legislation and say there's only a maximum of 4 members and only a maximum of 4 trustees, and they replicate the wording of the legislation. Most better deeds don't typically do that, because then it just means you've got to update them every single time the legislation changes. So our deed, it just allows trustees and members as per the relevant requirements. So for our, if someone wants to add a 5th member to a Merthyr Law superannuation fund deed, they don't need to change it at all. It's already ready to go. But if you are looking at the deed, just look at what are those trustee rules and what are those member rules. That's where you'll find if anything needs changing, really. And so that's a different concept. So whether it's allowed or whether it's prudent to have some extra provisions and safeguards if you're changing from just a mum and dad, I love you super fund, or sometimes there's not much love, depending on what stage of the relationship they're in, to a super fund where there's additional members, where there's either adult children, business associates, those types of things. Again, being involved in a lot of disputes, so it makes sense that we really, I guess, think about these concepts, and instead of just going with whatever the cheapest deed that you can get online is, really having a think beforehand of, what do we need in the deed? What are these rules? What level of control do we want? And workshopping through, different scenarios, which I'll talk through today. And, perhaps having a bespoke deed or a bespoke constitution for the corporate trustee, that kind of sets out some of those rules, like, a flatmates agreement, but, a governance agreement, so to speak, for their super fund, which really Hopefully the idea of those is when that's all streamlined, it's narrowing the potential for dispute. So, there's a roadmap to move forward rather than getting stuck and you have a 6-member fund and then you've got 6 lawyers all involved. That would be lucrative to us lawyers, but there might not be a lot of money left in the family, if that eventuates. So trying to avoid that. And what kind of provisions will we be looking at for these governance agreements, these bespoke deeds, these bespoke constitutions, these bespoke shareholders agreements? Typically focusing on if there's a dispute, what happens? How do you force someone who's annoying out of the fund legally? If there's members with bigger balances, do they get more of a vote? How does that reconcile with the trustee duties? Should there be, restrictions on who can contribute what? Especially where you've got specific property kind of funds, or, I've seen ones where you've had business associates and there's a really good asset in their property. And then one member's just putting this lazy cash in there and they're getting a bigger percentage of that property. Had one the other day where the lady, she let a daughter-in-law into her self-managed super fund. She was widowed. And she didn't think about it, but, I don't think she'd really kept the, the proper market value of, the main asset of the fund up to date. I mean, you're supposed to, but sometimes there's the market value for the financials and the market value for what you really take for that property. Then she wanted to sell the property, but this person, her daughter-in-law, put in 80,000 cash. They hadn't segregated that at all. And she was beside herself when we mentioned that might mean that her daughter-in-law gets, a fair chunk of the revaluation of that property. So, those types of things. So, yeah, there might be rules about when you can contribute, who can contribute what. There might also be some conditional memberships too. So, only these kind of people are allowed to be members and your membership's conditional and can be revoked in these circumstances. We're going through looking at what these opportunities are for 6-member funds. So having a look at how we can set up this family fund, perhaps intergenerational family funds, having a look at, what are other opportunities, some of those cost synergies that we can get. And then quite interestingly, looking at these specific assets and purchases, how we might design this for some specific asset holds and some tricks we can do there. And I'm excited to share that with you. So today I'll be using the same family largely. And I guess there's 2 kind of variations on this. So, for a 6-member fund, here we've got Jack and Jill, mum and dad, with their 4 children, Mary, Johnny, Little Bo, and Humdee. Now, a lot of people now don't have 4 kids. They can't afford them. Some of you Catholics and, some other families, they do have, those larger families with 4 kids, but there's a lot who don't. So it could be, you have all 4 of your adult children in the fund, or all 4 of you, they don't have to be adult. You can have minor children in the fund too. Or it could look more like Jill and Jack, and then they got their daughter Mary with her spouse Wee Willie, and their son Johnny with his spouse Marjorie. And I'm a bit tragic. When I was coming up with these slides, you must be able to tell I have got young children, because I came up with nursery rhyme characters was the best I could do. So apologies for the juvenile focus on these characters' names in advance. And so, yeah, potentially you could have the in-laws in the fund too. So for these family funds, what are we using them for? We could have potentially intergenerational retention of lumpy assets. And I've got an example of that later. Let's say if you've got that great business property and you don't ever want to sell, or you don't want to sell it for the foreseeable future, you want to keep it in the fund. So you can be using these funds to, use the kids' contributions to build their share up. And, whilst the parents are paying down their pension. And so, there can be a strategy to keep those assets and keep these funds going. There's no 80-year perpetuity period for self-managed super funds. So these things can last indefinitely, but it's harder since 2017 when they've limited how much you can keep in super when you die. So it's only that transfer balance cap, currently $1.7 million or whatever it's raised, over the years from that. Whatever's left in that transfer balance account is what can stay inside that super fund on the death of the first spouse. And on the death of both spouses, where you've got adult children, all of that, parents' money has to come out of that super fund. So, planning for what you might still be able to do there. And I got some examples of that later in the presentation today. So, another good one is, let's say you do have those lumpy assets. Sometimes they're a great asset, great growth, that kind of thing, which means you've got to update your financial statements for the market value each year with that growth. But sometimes the income that's generated from these assets isn't necessarily sufficient to meet those minimum pension payments. Having adult children in there can help out because you're using those children's contributions. They can contribute as a concessional contribution, $27,500 each. And then it gets this 15% tax taken off that. And, they get, they're only paying a 15% tax rate rather than if they're at the top marginal tax rate, that's quite a bit of tax arbitrage for the kids. And that very money that's left in the super fund is then taken out by the parents as their, minimum pension payments. They can use that cash. The kids are over time getting a greater proportion of that good, lumpy asset, and their percentage of the member benefits over time is increasing. Look, there's definitely some cost savings to have. So, the admin fee for one super fund with 6 members shouldn't be that much more than one super fund with 2 members. Shouldn't be 6 times, it shouldn't be, geez, my lawyer maths there, 3 times the price. I can't believe I had to think about that one. But that shouldn't, I submit that shouldn't be the sole reason for entering into these. When I talk about the potential pitfalls, we just got to be careful. The lawyer's fees in a dispute might be much more than those admin savings that you get. Also, I guess, one potential is, for the adult children, in today's legislative environment, they're not allowed to access their super until they're 60, unless something bad happens. And so this is a really good investment structure, I guess, where parents might be able to impart some of their investment philosophy and their financial philosophy on the kids, and they won't be having the pressure from the kids to take this out and use it on a holiday or do this or that. And they might be able to help introduce them to advisors, introduce them to, some financial concepts, introduce them to the value of, cumulative and capitalized returns and those types of things, to, I guess, help them on their financial journey of, becoming a more mature investor.
Kieran, so if I added my 2 adult children to an SMSF, will this be beneficial to avoid tax implications upon my death?
No, it might. Where you sell a lumpy asset, let's say if you're in, mum and dad were going to be 100% in pension phase, their assets were worth less than $3.4 million between them, and then they sold a big lumpy asset with a big latent CGT, then that could be entirely CGT free. If you've got the kids involved in the fund, well, the kids are in accumulation phase, so there's going to be some CGT that's payable there. So, it's not more beneficial from that perspective. And then for the other perspective, if you've died, it's just looking at that members balance. What's the taxable component of that members balance? And if that goes to an adult kid rather than a spouse, there's still that death benefits tax on there. So that doesn't change. So there can be some tax savings I'll get to later, but generally no. It could even be a worse tax outcome potentially.
And when adding adult children, is it best to only do this when parents step into retirement?
It's best when it, I guess, suits that particular family. So every family that we see in our estate planning and in our conferences is different. Every dynamic in a family is different. So it just depends when's the right time for them. I guess what I'm trying to stress today, and we've got to the opportunity so far, I haven't got to the pitfalls, is, it's not a decision to enter into lightly. You get your kids inside the fund and they've got their nose in all of your financial business. And, sometimes kids don't have that maturity. They think they know best. And, that can cause fights. So it depends on every kind of family dynamic. Definitely retirement's not necessarily the phase. It might work for some families, it might not. I guess all I'm saying here today is it's just part of a discussion as part of overall estate planning, overall financial planning, that this is available. Is it appropriate? And just because it's appropriate doesn't necessarily mean, just because it's available and you can have your kids in your self-managed super fund, doesn't mean you should. It doesn't mean it's a good idea, but it's worth talking about. One other, I guess, the converse of financially educating the young children is the converse. So the parents are getting old, and especially, in that case where you're, widowed, and it might have been, one of the parents was more into the finances than the other. And I guess then you got a problem where you've got someone who's not into their finances, potentially losing capacity, is in control of this huge nest egg for themselves, and they're open to financial abuse from outsiders, financial abuse, from one of their children, or just making bad decisions, or not being involved and getting fined, losing that money. Perhaps having the adult children involved in the fund, well, that's helping ensure that the adult children then know if anything's, if there's any sinister advisors or anything dodgy going on, and the younger ones can help make sure that their parents do the right thing with their money. Now, generally, I guess, where you had 4-member self-managed super funds and you had 3 siblings and you only had 3 children, you only had one of the children as a co-member of that fund, that causes potential issues. If that child's a bad egg, they might engineer things so they get all of that super. Where you've got all the children involved, well, they've all got to be rogues together and, come up with a united plan to defeat the parents. So, hopefully having the kids there might provide some protection to the parents. Just depends if your kids are black sheep or good kids, I guess. Also, I guess you got more members, you might have a bigger pool to invest, and you might get some investment opportunities and some better quality investments by pooling your cash together. And I think I mentioned before, we just got to be careful too. You have those adult children and then you go selling a lumpy asset. What might have been a tax-free gain might now be taxable. So, a bit of planning for those kind of things if you do have those big lumpy CGT assets in there. All right, one situation we see a bit, and typically it's the man, it's the father. It's not always, sometimes it's the mum. But you might have one person, the father in this instance, who's really into investing in shares and researching shares and kicking up with the super law and talking to the advisors and doing all of that kind of stuff. And in this case, the rest of the family's mum and the kids are more into socializing than they are into, looking at financial statements and researching shares and, trading and that kind of thing. And so it can be a bit annoying to have the party animals all involved in this 6-member fund. And, when dad's the only one who really, cares about that strategy and that investment. So one way, I guess, to just make it a little bit administratively easier is all of the kids and the wife could give dad an enduring power of attorney. Doesn't need to be over all their stuff, could just be over their membership interest in this fund. Then dad's allowed to be the sole director of the corporate trustee, or he could even be a sole trustee of the fund, but I wouldn't recommend that. He could be the sole director of that corporate trustee. He could do all of that investment. He's got to have the best interests of all of those members at heart. He's got duties. He's on the firing line rather than the kids if he does anything wrong. But, that can work, where you've got, I guess, more disengaged kind of members. So, they get the benefit of dad's hard work. The cost synergies, so, I guess you can save those admin fees. You might have cheaper advice fees where you've got a bigger, pool to invest there. And it might make self-managed super funds a bit more attractive. And I guess when you're having a look, you're still getting charged some form of platform fee or advice fees for your industry funds, getting your financial advice and comparing what that looks like, on the self-managed super fund level, if you got financial advice there versus what that looks like on the industry fund level. But you still want to make sure you're getting returns that are equal or better than the, overall returns that are equal or better than those industry fund returns. I think this is a potential benefit. In most cases, this might not be the main driver, but it might be. But we're still got to be careful of all these issues that come about by having kids or other people inside your fund. All right, now onto the specific asset purchases. So in this instance, we've got a company runs an engineering business here. And it's a bit of a sausage festival. Historically, we've got Dave, Rick, John, Ben, and Louis, all as directors, and their family trust as shareholders. They find the perfect premises they'd like for their building. And they hear that, it's pretty good to have it in your self-managed super fund because, you're increasing your retirement savings and it's this, great tax-free environment or, 15% tax rate. So they want to make use of that. Historically, what we've often done here is a unrelated unit trust. So that unrelated unit trust can then borrow and they might all have their individual self-managed super funds involved. Every time there's a transfer of a unit in one of those unrelated unit trusts, that attracts capital gains tax and transfer duty. So, perhaps this is another method where they set up a bespoke fund just to hold this one asset. They've got membership rules that only the directors can be the members of this fund. They got contribution rules. Everyone's got to have that equal contribution or defined contributions in this fund, and it can go and acquire that property. It could even do it under a limited recourse borrowing arrangement. If that's from the company itself, if it was financing the super fund getting into this, if it was helping the super fund geared, well, the gnarly rules, the safe harbour rules are that that's currently a 5.1% interest rate and 15 years, principal and interest and a 70% loan to value ratio. So, that's going to come down over time. Otherwise, you can go to the banks or the non-bank lenders. And I'm being told that their prices are coming down. So, that they are starting to get below, again, that safe harbour rule rate. But, generally with these loans, they will reduce over time when the property value will go up. Now, Louis wants to leave. He wants to retire from the business. So the super fund, rents, the business rents that property out from that super fund, market rate and, getting that appraisal at that front end. And so all of these guys, the business is getting a tax deduction and then it's funding their own retirement. At least they're paying that rental to themselves rather than to, the external landlord. They're also getting security that this really great premises is in their hands. The landlord's not just going to not renew the lease and they're kicked out on the street. The sole purpose has still got to be to maximise all of those respective members' retirement benefits. Now, what I would say for something like this, all this fund is set up for is to acquire this one property. So we don't want these members being able to make other contributions so they get a different share than what was agreed. There's rules against that. We don't even want this super fund to keep accumulating cash, whatever it doesn't need for its property maintenance and home. It would roll over to each of their respective superannuation interests if they've got their own self-managed super fund or the industry funds. It would do that regularly. So this is just the core that just holds this property. So Louis wants to leave the business. And they're finally getting a girl involved on the board. And so Sally comes in on that shareholder level. She buys out Louis' shares in the business. And what she could also do too is her super savings she's accumulated, she could contribute to this self-managed super fund, which would help pay Louis out. Now, if she doesn't have enough money to pay out Louis's member benefits, that could happen over time as long as we don't exceed that 6-member limit. So she could be putting those concessional contributions in and they could be rolled over to Louis's other super interests until he's reduced down to 0 and he leaves that fund too. Now, getting a trust interest in a super fund is not a dutiable event. It's not a capital gains tax event. There's no sale of the property, so there's no CGT event here. So this is a method where we can enter and exit business partners from this landowning entity without stamp duty and without CGT.
Hi, Kieran. So if a kid is making contributions to a super and that's providing pension payments to avoid selling a lumpy asset, what happens if that child gets a new partner and encourages them out of the SMSF? How to cash flow them out? Can they force the sale of the lumpy asset, which might not be a good time to sell it?
Emma, I've got a slide on that. I'll talk about divorce a little bit later in the session today. I guess just continuing on with this topic here is, what about this asset is going up in value and so it's got unrealized gains, and then I guess it's when it's ultimately sold, whoever the members of the fund are, they're the ones who are wearing that CGT. So, you know, on a longer hold, that's 10% in an accumulation phase for a superannuation fund. So one method that you can go here is tax effect accounting. So when you're valuing the assets of the fund, you attribute, you know, what's the unrealized, you know, potential CGT liability, and that's what you're funding it at, and that's what you're funding the entry price for Sally at too, and the exit price for Louis at. So as long as that's consistent throughout, that should all work out in the wash. So whoever's left when it does sell, well, that's already been accounted for. You know, nothing's perfect, but, you know, that's what you can do, I guess, you know, to help make sure that, you know, whoever the last people are in that fund aren't the ones who wear all of that tax liability and everyone else got out, you know, unrealized tax liability and everyone else got out scot-free. There's no questions on this slide, Emma?
None on this slide.
So here's another example. And in this case, there's a business, a restaurant, Lucky's Trattoria. And Luigi's self-managed super fund that he operates with his wife, Maria, it owns the freehold. And the business is owned and operated by Luigi's family trust. So the super fund leases the land to the family trust. Luigi's had enough of the restaurant business and he wants out. So he sells the business to Arabella's family trust. Might get some capital gains tax concessions. And so then the super fund is leasing the premises, the freehold, to Arabella's family trust. Now, Arabella is having a look at this and going, you know, it's really important for this restaurant of where it's located. And, you know, it'd be great if I had some security there to know that I'm the landlord and the landlord's not going to sell me out. And so she'd love to buy that freehold, but just doesn't have the means to do it yet. So potentially that same scenario as last time is Arabella here. She could use some of her super fund savings, get a husband and a dad involved too, and they might contribute a bit to Luigi's self-managed super fund to pay out some of Luigi's and Maria's benefits. And again, over time, if the rentals, you know, it's positively geared, all of the excess cash could be used to pay out Luigi and Maria. Arabella could be making concessional contributions and her husband concessional contributions into the super fund until Luigi and Maria's member benefits are 0 and they can exit the fund. We could rename it Arabella Self-Managed Super Fund at this point. And, even though we've had that massive deed change, that's the nature of superannuation. That's not a CGT event. And there's some special rules, about no resettlements for deed changes for self-managed super funds. And so they managed to do this without stamp duty and without capital gains tax at that level. Obviously, you'd want that tax effect accounting because they want to come in and go, well, if I do sell that property, I don't want you, you've escaped all your capital gains tax liability. So, that would be taken into account in valuing all of those interests. Now, alternatively, I guess Arabella could have her own self-managed super fund, and she could enter into, with her dad and her husband, and enter into a limited recourse borrowing arrangement with the bank to buy that property if that's on the table. Typically, there's stamp duty there. Perhaps there's a method, in Queensland, if it's a demerger or merger of a super fund interest, you can escape stamp duty in that instance. So there is potential where we could have them as members and, do this and, get away with that transfer duty. There are some integrity measures in that. It's a concession. I think you pay $20 duty in Queensland. And it differs a bit, those exemptions between different states. I was looking at WA yesterday, and in WA, you can't pay consideration for that asset. So, that could be a bit more difficult getting outside of duty there. But if you are transferring between self-managed super funds, capital gains tax does apply for that transferring fund. Those exemptions on, merging superannuation funds like CGT rollover relief, it only applies to those funds with, it was more than 5 members or more, and now it'll be more than 6 members.
So we do have a question, Kieran. So can the self-managed super fund that holds a property become a vehicle where people use their superannuation money to hold the asset in a capital gains tax-free and stamp duty-free environment? For example, the members can come in and out and the members are not related. So can they use that fund as an investment too, for investing in the property?
For investing in that property, was it?
Yes.
Yeah, there's rules about borrowing and gearing, so you can't redraw on your loans, but definitely that is the case. You could have unrelated people coming in and out of the fund, which was like this example with the engineering business. You just want pretty robust rules, and you want what that specific asset are, and pretty robust rules around what that is. And you don't want it to be just the vehicle for everyone to be having their personal investments in. You want their personal investments to be done outside, and this just be focusing on that one asset. But yeah, you certainly can. And then, depending on what, I guess, if there are members in that retirement phase, there might be the potential to save some capital gains tax, when an asset like that is sold. But yeah, you could get another member into your fund to help, I guess, develop a property. If the super fund own land, so instead of doing a joint venture with which the ATO, sometimes without reason doesn't like, where the super fund just owns the land, you could find some investor who just contributes money to the super fund. So all of these things are possible. People to date have avoided doing these kinds of things, like, even this freehold one, that could work just with a 4-member fund. You don't necessarily need a 6-member fund. And I guess, it's just like when you sell shares in a company, you've got to be careful. What's the track record of the super fund? If we're scared about that, is there rollover relief for us getting into another fund? And then having those rules in place to kind of mitigate that risk. So, I think that's what, great kind of question is, perhaps we put that cap on and treat a self-managed super fund a bit more like we do a company, where you can have people come and go from that company. You just need, robust negotiations and agreements for, what those rules are under the shareholders agreement, and that type of thing. All right, back to our family. And here we've got Jack and Jill, mum and dad, have got Johnny and Marjorie, their son and daughter-in-law, in their self-managed super fund already. And they want to get their other daughter, Mary, and her husband in the same fund. They decide they'd like to just combine their funds. Jack and Jill Super Fund has got residential property and commercial property, and Mary and Wee Willie's fund has just got a commercial property and some other investments. So we could roll over the commercial Mary and Wee Willie's member benefits to the parents' fund. And in Queensland, we get stamp duty relief also from rolling over that asset over from the Mary and Wee Willie's fund to Jack and Jill's fund. However, there's still that CGT that's payable there. There's exemptions, rollover relief if it's part of a divorce. So, if you're rolling over a benefit as part of a divorce and as part of the court orders, you can get that CGT rollover relief. But, that's the problem for these smaller funds is, there can still be that capital gains tax. We have struggled getting residential property rolled over from one fund to a related party fund because of those acquisition rules. Section 66, it's not business real property. We can do that as part of a divorce again. The other way around, we had this fund with all 4 of Jack and Jill's kids. And for whatever reason, Jack and Jill passed away and the kids wanted to go their own way. There was a bust up, whatever the reason is, there's hundreds that could be the case. The kids want out. So again, the commercial property, the resi property, Mary they could all have cash amounts rolled over to their respective funds. And then Mary could actually be having a limited recourse borrowing arrangement to acquire this property. So she's injecting, instead of, if it's unencumbered, she's utilising the equity in that, leaving more cash to pay out the other kids' member benefits. And potentially, depending on what state you're in, you might be able to get some stamp duty relief for, this demerger. We can't get that resi property out, like I said, to that related party fund for those acquisition rules. And it might be that there's just cash to get to Humdee and Bose into their industry fund. Quite often contributions for parents is pretty popular. We don't need a 6-member fund for doing this. But for example, here, Mary and Wee Willie, they're making the maximum concessional contributions each year. They've got a business in their family trust generating good income. So they distribute, here, $55,000 to Jack and Jill, their parents, who contribute it to the fund, just that 15% tax rate. So some tax arbitrage there. But Mary and Wee Willie, with all of their siblings around, they want to make sure that if Jack and Jill pass away, that they get the benefit of all these contributions that their family trust has been funding for them. So, at least if they're part of that same fund, they're able to keep an eye on it and making sure, the binding nominations are kept the way they'd like them to be kept. So that's going to end up back with them. Alternatively, if Jack and Jill are over the age of 60, Jack and Jill could, after the 15%'s been deducted, take that money back out and, gift it to Mary and Wee Willie. But, potentially with that trust income, is that, part of a reimbursement agreement? Is that, a normal family dealing? Is that Part 4A? Those are the kinds of things that's got to be considered where you've got that immediate kind of refund of that cash. Intergenerational funds. So in this one, again, I'm not advocating single asset funds, but just for this example, this is what we got here. Jack and Jill have got $1 million member benefits each. Each of the kids have got $250,000 each, and they own a $3 million property. A really good property. They'd like to keep inside this structure and not have to take it out of super. Jack passes away, reversionary pension, so nothing needs to happen. That property can stay in there. Now Jill's got $2 million per member account that's kept in there, business as usual, until she passes away. Then that $2 million has got to come out. If we wanted to keep this asset in there, there's no other cash in there, we'd need a $500,000 non-concessional contribution per child. Now, under the current contribution rules and bring forward, that's 110 per year. So utilising June and July, we could get 440 in per child, but 500 pushing it. We'd probably need to get one of the in-laws involved if we wanted to, not have to remove any of this property from the fund. Otherwise, they'd be exceeding those caps and have to get that money out. What I haven't factored in here is of that $2 million, that's going ultimately to the kids or via their estate to the kids, and then put back into super. We've got to take that death benefits tax out. So, the taxable proportion, if it goes to the estate, 15%. If it goes directly to the kids, 15% plus that Medicare levy. But, these are the kinds of things that you can think about of if you are buying a property inside a super, it's worthwhile thinking about, okay, we've done all of this. What's the plan when we pass away? What's it going to cost? What's it going to look like? Because nowadays you have to move that money from super. So, part of your conversation, part of your thinking should be, what does that look like? What are the potential costs of getting it out? We've got tricks where we can get assets out of super to family trusts in Queensland without stamp duty. But, those are the kinds of things that should be in, I guess, the checklist of the conversations when you are buying a big lumpy asset inside a super fund. And it might be that having the kids involved, helps that out. Okay, that divorce question, Emma. So I don't know why Mary has broken up with Wee Willie, Winky, but she has. They divorce. And so Wee Willie, depending on his family lawyer, he can seek a superannuation split with Mary, so he can get Mary to split all of her $275 to him. It can go vice versa too. The parents, Jack and Jill, don't really have control over that. And so, that's the potential here is, okay, if they do divorce, what does that look like? Are we stuck with Wee Willie in this fund? Our standard D, we've got a provision there that majority of members can force an exit of another member, even if they don't agree, that's valued. If they don't give you a fund, we can transfer it over to an eligible rollover fund. So even if Wee Willie did engineer that, we could pay out that money, that $550, if he got all of Mary's super too, if he's a shrewd negotiator, but we'd have to find that $550. So, coming up with our plan of, okay, if someone does divorce, what is the process? You can do those superannuation agreements. So it might be, hey, you want to, Mary and Wee Willie, you want to come into our self-managed super fund? Well, you need to have what's called a financial agreement, but you can even have narrow it just to the superannuation interest, so a superannuation agreement, which can say, in the event you two split up, Wee Willie's got to split his super in favour of Mary, and so, it can be as simple as that. They both got to get their own independent advice, and that can be done. Or it might say that they both keep their own super interest and they're not going to split it at all. They got to go get that lawyer's advice, but those are enforceable if they're done properly. Then I guess if you do have a borrowing arrangement inside one of these, well, when you sign, the 20 documents you sign with the bank, one of those is typically, hey, if there's any changes to the fund or the membership, you got to tell the bank and we've got to redo our documents. So the exit of any member, is a cause for review of the loan facility. If it was the 4 kids, no in-laws, it still could be Mary divorced Wee Willie, then he could still, in the family court, get a split of that super in his favour. Usually what happens there is when it's not his family, that process is, well, then that benefit then gets rolled over to where Wee Willie's own fund. But, having those contribution rules that, not anyone can be, membership rules, not anyone can be a member of this fund, and that we can force that exit. That's important, really important in these kinds of arrangements. All right, one of the biggest problems with families I just see typically in estate planning is when you throw money and finances in the mix, and then that's a cause for fights. As Jay-Z said in one of his songs, is nobody wins when the family feuds. So you're forcing this financial relationship on the kids, and you're forcing this relationship on the kids, and that can cause, fights. So one kid, has particular investments they want to do. Another kid's refusing to engage, won't sign any documentation. In-laws start whispering ideas in the kids' heads. And someone, suggests an investment and it's a real dog and it goes badly. All of these things, you put money in between family and that can cause disputes. One kid wants out, the others resent that. So, everyone says my family wouldn't do that, but, we see the bad end of it as lawyers. So, forcing a financial relationship between children, sometimes isn't ideal. The other one is, I guess, if you're the parents and you got the lion's share of the members' benefits, you get your kids involved. They've got a legal right to the financials and a legal right and duty to review them. And so you have some kids, that goes to their head and they think they should be in charge of everything, and, it might change the dynamic. A lot of parents don't want their kids knowing those details of their finances. You have them inside the self-managed super fund, which is for a lot of parents now the biggest vehicle for that wealth, apart from their family home. They don't necessarily want their kids knowing and, having influence and veto rights over, their finances. So, that's a big one. Individual trustees. So look, here we've got 6 individual trustees for a self-managed super fund. In Queensland, the rule are you're only allowed 4. So which 4 is it if we've nominated 6? And I looked into this in the past. It's the first 4 mentioned. So here, Mary and Bo don't get a vote legally because they're not really trustees. I don't recommend individual trusteeship, especially not when you've got more members, because every time a member exits or enters, you got to change all of the title to the shares and the properties and all of that kind of stuff, and it's a headache, whereas changing who the director is on a company is really simple. So I do recommend companies. The other thing about individual trustees is trust law says they've got to act jointly. And we all know getting 6 people to agree can be pretty difficult. And what it means is if one person vetoes, is just whatever the proposal is doesn't happen. So you might be left with a fund that's just stuck in cash for the rest of its life because nothing ever happens because you get one person who's vetoing everything. So I don't recommend them, individual trustees, especially not with more members. Let's say we've got a corporate trustee. So then, here we've got 6 directors potentially. Mum and dad can get outvoted, can't they, in your standard company? So the kids can gang up on them. So there is this concept where you might have weighted voting. So each director gets a vote in accordance with their membership interest in the self-managed super fund. We've still got those duties that we've got to follow, that we act in the best interest of the members, etc. Those covenants. Can't just mum and dad, just because they have a bigger member balance, doesn't mean that they can ignore the best interests of the other members. Would recommend, those shareholders' deeds, a bespoke constitution for this type of arrangement, because otherwise it's simply majority wins, and that's not good for those founders. That before they enter into this, you'd want to really set out that rule book. Now, here's one thing to watch out for too, I guess, is, where it's just mum and dad, they can break up and bust up. The family court rules, family law rules deal pretty well with that. Where you're dealing with kids or business partners, we're looking at trust law and super law, rather than just relying on the stock standard part of the family law settlement. Say Section 55 of the SIS Act is anyone involved in a breach of the covenants under the SIS Act, acting in the best interests of the members, the investment duties, etc. They can be liable for compensation. So it's not even just the directors or the trustees. It could be if you were advising them in a course of action which was against the best interest of another member, you could potentially yourself be liable for compensation and not indemnified out of the assets of the trust fund. In general trust law, you've also got that duty not to act in breach of trust, to act in the interest of the beneficiaries. And these trust law duties are, largely replicated in the SIS Act, that they're part of the governing rules. And, you can be a trustee can be liable for breaching those. That's acting in the best interests of all members. that fiduciary duty to the members. So not just looking after yourself as a member, making sure you're looking after those other members, investing prudently. It's a covenant to have that investment strategy, which deals with things such as, liquidity needs of the members, their investment portfolio, and carrying out that investment strategy. So if you've got this investment strategy and then the trustees ignore it, that could be grounds for compensation. There's also these portability rules too. So if a member says, I want out, this law says, well, a trustee's got to accommodate that. And the starting point is they got 3 business days to accommodate that, which for a self-managed super fund is just impossible because we don't even know what it's worth within 3 business days. We don't have those, units that are valued every day inside of these types of funds. Otherwise, it's 30 days, if they can't, but as soon as practicable. Or I guess if their fund has a liquid assets, and the members have agreed to be in the fund with the liquid assets, then it can be, a longer period reasonable to realise those assets. So, trustees can get in trouble for breaching these portability rules, and that is something that they can get fined for too. So, something, I guess, if we do have these lumpy assets, we've really got to do that front-end homework and making sure everyone's signing off, that it's anticipated that it will take this amount of time to redeem your benefits. It's not going to happen overnight. All right, we're about out of time now. And I guess, so the theme I'm trying to impart a bit today is just because we can let the kids into the fund or let our business partners in the fund, doesn't necessarily mean that we should. There's a lot to be said of just keeping your finances separate and being in control of your own stuff. As lawyers, I quite like it if people, get into these kind of fights, because we earn more money from fights than we do from, the front end work. But if you do decide that it's a good idea to have your kids or your business partners into a joint fund, we'll plan for it. If you fail to plan, you're planning to fail, and the lawyers get involved. But the more you stress test about what happens if someone dies, what happens if someone divorces, what are the rules, what happens if someone wants out, what happens if we have a fight, who gets what votes, then at least you're minimizing the ambit of a dispute, and hopefully it's a little bit more seamless in managing the exit of one of those or more of those members. Questions, anyone, or anyone got any other ideas what we can use these 6-member super funds for?
So we do have a couple of questions. One was, how important is it to ensure all members have life insurance within their fund?
It's actually a legislated covenant. So, the trustees are under a duty to consider the life insurance needs of the members. So that's something the trustees got to consider. And, that should be recorded in the minutes and in the investment strategies. And all of that depends on the needs of the member and, their age and the cost of the insurance.
Another question was, if an employer only pays an employee's super contributions to, i.e. HESTA super fund for all their staff, is there any way to get around this other than making regular rollovers into a self-managed super fund?
Yeah, look, generally I thought the rules for choice of super is you can direct your employer to pay your super in a certain manner. There might be some specific awards which are still behind that, but I thought that was, the consequence of, changes a few years ago, that employees have choice of their super. There is the concept of default funds, so the employer can recommend a fund, and you stick with that. The employee sticks with that fund now, throughout their changes in jobs. But generally, yeah, the rule is you nominate your super fund, and providing you meet the payment standards and you set up for super stream and that kind of stuff, yeah, you can tell your employer, pay it direct into the self-managed super fund. A bit easier than, trying to do a rollover between the funds every month. That's a bit of a hassle.
How about 3 generational funds that include children? Do you see that a lot?
Children and grandchildren?
Yeah.
I've never seen it. I guess what would be more common is you have the children, parents pass away, and then the children have their children, so that could continue on. Nowadays, we've got to get that money, we're only allowed that, maximum transfer balance cap amount in super when someone dies. Sometimes having infant children in a fund helps. You might get some government co-contributions and you can make contributions for the minors, that type of thing. I personally haven't been involved in a super fund where you've got the parents and grandchildren in the one fund. Maybe that'll change with 6-member funds.
And with the recent changes to the law, do you know why the ATO cancelled the ability to borrow against a super fund via like a bare trust?
Sorry, can you repeat that?
What was the purpose behind the ATO cancelling the ability to borrow against a super fund via a bare trust?
The law hasn't changed there. The ATO has kind of, I guess, been focusing on what the tax consequences are if you have more favourable arrangements with related party lending. Some of the banks have got out of that space, but the laws remain the same. Yeah, you can't, in the one super fund, you can't redraw on an equity in an existing asset, but you can still borrow to enter into borrow for limited recourse borrowing arrangements for self-managed super funds. There's some restrictions of, what that where it's related party that those contributions, that the amount of the loan is deemed to be part of your total super balance. So that can affect your ability to pay it off. But yes, we can still borrow in self-managed super funds. The law hasn't changed since the 2010 insertion of section 6748.
Well, that's all the questions we have from the attendees. So I guess it's up to judging the best question. And the winner is Albert for keeping Kieran on his toes and coming up with the most creative questions. So
Albert, we'll be in touch with you and you can let Emma know what wine you want of. I think we've got a 2013 Shiraz or a Eileen Hardy Chardonnay. Let us know what your preferred tipple is. And look, I guess everyone, I put these things on. There's a bit of work involved in getting the slides ready and having these chats, but I like to, put myself out there and offer this. I don't want to charge for it. But if you do like the service, let us know. And ideally, if you can, let me know by a recommendation on LinkedIn or a review on my public profile Facebook page, that would really help. Just say, hey, enjoy your presentations. That would be a great way to give back. And, I'm always around to answer your questions. I love talking SMSF issues. Anything else, Emma?
Nothing else. No other questions.
All right, everyone. Well, thanks for your participation today. Have enjoyed looking into this and, doing a bit of a deep dive into increasing the number of members in a self-managed super fund. And hopefully I'll catch up with you all at some time soon.